All right, everyone, let's talk about some doctrine from the 10th Amendment, also known as the States' Rights Amendment. We're going to look at case law, specifically the case of Reno versus Condon. This was a 2000 U.S. Supreme Court decision. It was unanimous. It was written by Chief Justice William Rehnquist, fairly conservative guy, and what it basically involved was regulation of DMVs, specifically the Driver's Protection Privacy Act of 1994. That act regulated disclosure of personal information in the records of state motor vehicle departments. It made a regulatory scheme which restricted the state's ability to disclose a driver's personal information without the driver's consent. So the act generally prohibited any state DMV, officer, employee, or contractor from knowingly disclosing or otherwise making available to any person or entity personal information about any individual in connection with a motor vehicle record. The state of South Carolina is going to take issue with that. Their Attorney General, Condon, who's in the name of the court decision, files suit. They argue that South Carolina law conflicts with this law passed by Congress, and so the DPPA is unconstitutional under the 10th Amendment. This makes its way to the U.S. Supreme Court, and Chief Justice Rehnquist ends up holding that this does not violate the 10th Amendment. Specifically, it does not violate the federalism principles that were articulated in the Prince decision. Prince was from 1997, and it was about gun control, actually. Not so much the Second Amendment, but mostly the 10th. So that case basically articulated the idea of the anti-commandeering doctrine. Commandeering is this idea that the federal government is telling states to tell private parties within their state borders to do certain things. Basically bossing states around to boss people around within the state and have states basically controlling their own private parties. And that is unconstitutional under the 10th Amendment. States have that power. It's more of a procedural thing rather than a substantive thing. Like, it's not any substantive law that states have, substantive power that states have regarding certain areas of law. It's procedure. You know, the federal government can't violate these procedural restrictions of telling states what to tell private parties. So Justice Rehnquist ends up writing, "We agree with the U.S. government that it was regulating interstate commerce. Interstate commerce was at issue here. South Carolina argues that the law violates the 10th Amendment because it, quote, thrusts upon the states all of the day-to-day responsibility of administering its complex provisions." Chief Justice Rehnquist writes that the Baker decision is controlling. Baker upheld a statute that prohibited states from issuing unregistered bonds because the law regulated state activities rather than seeking to control or influence the manner in which states regulate private parties. And that's important to the anti-commandeering doctrine analysis, is states regulating private parties or regulating states themselves. And when you regulate states themselves, that is a generally applicable law. So the DPPA doesn't require states to regulate their own citizens. It just regulates the states as owners of databases. South Carolina argues the DPPA is unconstitutional because it regulates the states exclusively. Basically, they're arguing that Congress can only regulate states by means of generally applicable laws. So they're saying, it's a requirement that a law be generally applicable in order to comply with the 10th Amendment's anti-commandeering doctrine. And how the Supreme Court responds to this is they say, we don't need to address that. We don't need to address that because actually this law is generally applicable to begin with. We don't need to address whether or not there's a requirement that a law be generally applicable because this thing is generally applicable. That's something kind of common with U.S. Supreme Court decisions where they say, we're going to leave that question for another day. Another decision can handle this. And so here they're leaving the idea of a requirement for general applicability to another day. They say that this law regulates the universe of entities that participate as suppliers to the market for motor vehicle information, and therefore this law is generally applicable. So win for the federal government here. States' rights end up losing. It's a unanimous decision. Even the more pro-states' rights people on the U.S. Supreme Court side with the federal government rather than South Carolina here. So the anti-commandeering principle, it's the idea that, states don't get to tell private parties what to do. It's like if you have parents and they have 7 kids, they can't tell their oldest kid to tell their younger siblings to do stuff. Like say, hey, tell your younger siblings to clean their room. But they can't say, hey, all 7 of you, clean your room. That's the anti-commandeering principle. That's a metaphor that I think is pretty helpful. Let me know what you think about this court decision in the comments below. What do you think of anti-commandeering? Is there any question that you would like me to answer in the comments below? Are there any U.S. Supreme Court decisions you'd like me to talk about in a future video? I love constitutional law. It's my hobby horse. I love the First Amendment and civil procedure. I have plenty of videos on those topics. Please check those out. Please subscribe to the channel. Leave a like. Leave a comment. Thank you so much for watching. I hope that you can take this video to the bank and use it to get an A++ in your constitutional law course. Law students, I am always here to help.